Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney MacDonald is, my student is disciplined for something he or she said off school grounds. Is this legal? And what about my child's First Amendment rights?
A student may be disciplined for expressive conduct occurring off campus when such conduct would foreseeably create a risk of substantial disruption within the school environment, at least to the extent that it was similarly foreseeable that such off-campus expression might also reach campus. Whether there is a risk that the off-campus speech will cause a substantial disruption within the school environment depends upon a number of factors, which include the language used, the truth or falsity of the communication, and whether the student serves as a student government leader. Further, educators are permitted to exercise editorial control over school-sponsored expressive conduct, such as school publications like a yearbook or theatrical productions. Please note that courts have held that participation in extracurricular activities is a privilege and not a right. While students retain their constitutional rights of freedom of speech or expression while in or out of school, school administrators may prohibit student expression that will materially and substantially disrupt the work and discipline of the school. Further, public school administrators may take steps to safeguard students from speech that can reasonably be regarded as encouraging illegal drug use. Additionally, a school may regulate conduct and expression in the classroom that's plainly offensive speech. For example, speech that is offensively lewd and indecent. Therefore, students and parents should presume that any communication, like a text message, tweet, Instagram, email, or any type of creation that a student creates, like an Instagram or Snapchat story, that can be forwarded to other individuals may be forwarded to parties that are unknown and may be seen by teachers or the school administrators. Also, any school-related electronic communication, for example, anything relating to school activities, students, teachers, administrators, can be expected to find its way on campus. Going forward, with respect to electronic communications, students should presume that there is no practical difference between what is said off campus versus on campus. What constitutes a substantial disruption within the school environment depends entirely on the circumstances. Virtually any deviation from the daily routine resulting from a student communication can be described as disruption sufficient to support student discipline. In conclusion, any off-campus electronic communication relating or referring to students, teachers, administrators, or school activities has the potential to result in student discipline. As of now, the law affords school administrators wide latitude in deciding when a student communication can be reasonably seen to foreseeable risk of academic disruption. Courts have found that exclusion from extracurricular activities is an acceptable form of punishment for inappropriate student speech. If you have any questions about your child's First Amendment rights to free speech or expression in the school environment, please feel free to give me a call.